5 legal documents everyone should have. In this video we explore 5 important legal documents and learn what they are and why they are so important. Will, living trust, advance directive, durable power of attorney, and financial power of attorney. This video is not intended as a substitute for an estate planning attorney or a law firm. As I'm not an attorney, I can't advise you on your documents' legality, or which ones your particular situation needs. Each state has different laws. If you fill out your forms yourself, you might want to have an attorney look them over to ensure your wishes are carried out as stated. Will. A will is a document that specifies how you want your property and assets to be distributed after your death. It also names an executor who will carry out your wishes and a guardian who will take care of your minor children if you have any. What is not included in a will? Some types of property aren't usually covered in a will, for instance, insurance policies and bank accounts. This is because they should have beneficiaries listed. Thus, a will usually isn't needed. What will happen to your property if you die without a will? It will go through a process called probate. In probate court, a judge appoints an executor who decides how to dispose of your property. In other words, the judge appoints someone who decides who gets what even if it wasn't your intent or wishes. Another reason a will is essential: witnesses. Depending on your state, your will may need to be witnessed. If so, it's best to have someone that is not part of the will fulfill that role. Having no interest in the matter, this person will be seen as being impartial. Some states do require 2 or more witnesses. Updating your will. You may or may not need to update your will. It's a good idea to look at your will every 2-3 years and when any major life events occur, such as a marriage, divorce, birth of a child, or death of a beneficiary. Contested. Even though you have a will, it can be contested. A contested will means someone is disputing or challenging its contents. Maybe a family member feels they were slighted or believes laws regarding probate weren't followed. Wills can also be contested if someone thinks you weren't of sound mind or were coerced when signing the will. If you believe there is a possibility that someone may contest your will, you can include a no contest clause. This type of clause can state something to the effect that if a beneficiary challenges a will, they will lose any inheritance stated in the will. Revocable living trust. A living trust is a legal entity that holds your assets during your lifetime and transfers them to your beneficiaries after your death. Unlike a will, a living trust does not go through probate. Revocable means it can be changed at any time during your lifetime, assuming you are mentally competent. Be aware that revocable living trusts need to be funded. Funding refers to transferring ownership of the property from your name to the name of the trust. If you have a revocable living trust, you still need a will. Why? Because a revocable living trust only covers assets with a title, such as a home, retirement account, car, etc. It doesn't cover property such as furniture, jewelry, or photographs. You also cannot assign a guardian for dependents in a living trust. Advance directive and durable power of attorney for healthcare. These 2 essential documents give someone the power to make healthcare decisions, should you become unable to make them for yourself. The advance directive puts into writing and clarifies your wishes regarding healthcare if you become unable to voice your wishes yourself. This may be because of injury, illness, or psychological issues. A durable power of attorney for healthcare appoints a person to make your decisions in the event of mental incompetence. You'll want to be clear about how the person you select should proceed with your healthcare choices. This can include consenting to or refusing treatments, surgeries, medications, and life support measures. A healthcare proxy can help you ensure that your wishes are respected and that your family and doctors are on the same page. Financial power of attorney. This is a document that authorizes someone you trust to act on your behalf in financial and legal matters if you are unable to do so yourself. This can include paying bills, filing taxes, selling property, and accessing bank accounts. The financial power of attorney gives whoever you appoint the right to access your bank accounts and to make financial decisions for you. Due to the power that the document gives the person you designate, choose someone you can trust to have your best interest at heart. Because you need to be mentally competent for the document to be considered legal, it's essential to have this document in place before you need it. FAQs. Can I make handwritten changes or corrections to estate documents? Handwritten changes to legal documents can invalidate them or create confusion. Consult with an attorney to make proper amendments. What happens to my estate documents if I move to a different state or country? Laws regarding these documents can vary by jurisdiction. If you relocate, it's wise to review and update your documents to ensure they comply with the laws of your new residence. How do I store my estate documents securely? It's essential to store these documents in a secure location, such as a safe deposit box or with a trusted attorney. Ensure your loved ones know where to find them in case of an emergency. Completing estate planning documents may seem overwhelming but can be so worthwhile. Once in place, you will have peace of mind knowing that your wishes are clear, leaving your loved ones with a clear understanding of what you want. Thank you for watching. To read the full article, go to livingyourseniorlife.com. The link can be found in the video description.